Hello guys, today we will be doing lesson 5 of Cjua042 and today we will be doing the limitation of rights. We are at number 4 on your schedule, the 14th of August, limitation of rights. You'll find limitation of rights in page 150 to page 176 in your textbooks. Okay. Now, before we start with the limitation of rights, in an ideal world, we would all wish that we would have full access to all our human rights at all times. This is, however, not an ideal world. We live in a world where, for various reasons, whether they be social, political, economical, our rights get limited on a daily basis. When the government limits a right, it's the job of the Constitutional Court to decide whether these rights are justifiably limited. In order to do this, the Constitutional Court makes use of Section 36 in the Constitution, which contains relevant factors that the court would consider before deciding whether a right is being justifiably limited or whether this right is being infringed upon. Now, before we move on, let's first look at the word limitation. What does this word actually mean? What does it mean when your right is being limited? Now, there are certain words that we can look at. The normal dictionary definition or synonyms would be restriction, restraint, limit, constraint, etc. The words that you can focus on is the word restriction or the word restraint. Now, if we look at the word restriction, what this would mean is when your right is being restricted or limited, it would mean that you do not have full access or full enjoyment of the right. The easiest practical example is we all have freedom of movement, the right to freedom of movement, which means that nobody can constrain your movements. But if you commit a crime, the government, and you are convicted of this crime, the government will have the right to restrict or restrain or limit this right of movement for the bigger welfare of society. That would mean that so what we can basically say is that a limitation of a right is the infringement or justifiable infringement of this right. A law that limits a right therefore infringes that right. Now, as we know, we are all supposed to have full access to our constitutional rights. So does it mean if we limit a right that it is then unconstitutional? Is the limitation of rights always an unconstitutional matter? Well, if the limitation takes place for a reason that is accepted as a justification for infringing rights in an open, democratic society based on human dignity, equality, and freedom, then the infringement would not be unconstitutional. So that is why we have Section 36, called the General Limitation Clause. It tells you that yes, there are situations in which your rights will be infringed upon. Your rights will be limited. But in order to determine whether it's unconstitutional or not, we use Section 36, which is... There are some words I want you guys to focus on. First of all, it should be justifiable. So the limit must take place for a reason that is accepted as a justification. So that's the first thing. It should be justifiable. When should it be justifiable? It should be justifiable in an open and democratic society. So it should be justifiable within the constitutional dispensation of South Africa. And this justification of this limitation should be based on human dignity, equality, and freedom. So whenever a right in South Africa is being limited, it has to be limited in such a way that human dignity, equality, and freedom are not being infringed upon in a way that cannot be justified. And that is why we use Section 36. Now the question we ask ourselves is, does the general limitation clause mean that all rights can be limited for any reason? Quite simply, it must be emphasized that the existence of the general limitation section does not mean that the rights in the Bill of Rights can be limited for any reason. It is not simply a question of determining whether the benefits of a limitation to others or the public interest will outweigh the cost to the right holder. If rights can simply be overridden on the basis that the general welfare will be served by the restriction, then there's little purpose to constitutional entrenchment of rights. So basically what we're saying is we need it to be more than simply what is good for society. We cannot just say that the general welfare of society will be served by this restriction, because there are many restrictions that the general society will be served by, but it has to be a weighing of options between the right holder and the limitation of the right. The reasons for the limitation need to be exceptionally strong. It must be justifiable. The restriction must achieve the purpose it is designed to achieve. And this tells you that there must always be some logical reason for the restriction. And then no other realistically available way in which the purpose can be achieved. In order for the court to determine whether a limitation is justifiable or not, the court follows a two-stage approach. So the general limitation clause applies to all the rights in the Bill of Rights and provides that all the rights may be limited according to the same set of criteria. That is why we call it a general limitation clause, because it applies generally to all the rights in the Bill of Rights. Now, in this regard, the Constitution differs from many other Bill of Rights and international rights instruments. For example, in the United States, their Constitution does not have a limitation clause at all. The German Bill of Rights, on the other hand, does not have a general limitation clause, but contains specific limitation provisions attached to many of the fundamental rights. So we have a general limitation clause for all the rights. The United States has no limitation clause, so their rights cannot be limited. And then the German Bill of Rights, they have specific limitations for specific rights. So, for example, the right to education can be limited in a specific way, where the right to life will be limited according to a different set of criteria, where in South Africa, all constitutional rights have exact same criteria. A similar structure is found in many of the international human rights instruments. The principal model for the South African Bill of Rights is the Canadian Charter of Rights and Freedoms, which contain a list of rights and a general limitation clause governing the limitation of those rights. Now, because we have a general limitation clause in the Bill of Rights, the court has to have a very standard test to determine whether the limitation is justifiable. So our courts use a two-step system. So when an applicant alleges that his right has been infringed, the court will ask to apply the two-stage approach. The first stage. First, the court will determine whether a right has in fact been infringed by the conduct of the respondent or by the law. So if a person approaches the court and, for example, says, the fact that I am not allowed to live in a building in the middle of central city Joburg, an abandoned building, the fact that I'm being evicted from this building is infringing on my right to housing, to adequate housing. For the court to determine this, they would then first go see, when they look at the facts of this matter, is there a constitutional right? And if there is a constitutional right, is it being infringed by the conduct of the respondent or by a law of the state? This is the easier part of the analysis. When the court is done with this part, only if the answer is yes, they will move on to the second part. And this is whether this infringement can be justified as a permissible limitation of the right. Now, what this implies, during the first stage, all the arguments and evidence required will be brought by the applicant. So the person that's alleging that his right is being infringed, this part, stage 1, will be his job to bring all evidence. If the court then decides yes, a right is being infringed and it is by the conduct of the respondent, they move on to stage 2. The respondent, which is usually the state, but sometimes it can be another person, may then seek to demonstrate that the infringement of the right is nevertheless permissible in terms of the criteria for legitimate limitation of rights as laid down in section 36. So here we've determined that right has been infringed on, and then in stage 2 the respondent will then have to say, yes, we are infringing the right, but it is permissible in terms of section 36. So the respondent will then have to lead evidence to prove this. But even if the respondent makes no attempt to discharge its burden of justification, the court must nevertheless consider the possibility that a limitation of rights could be justifiable. So sometimes it does happen that the respondent will not bring any arguments to the table. He's not saying it's justifiable or not. He's just saying, yes, the right is being infringed. Then it would be the job of the court to, irrespective of that, to still do the investigation and determine whether the limitation of stage 1, which was confirmed in stage 1, could possibly be permissible in stage 2. Okay. Now we are moving on to the actual criteria for justifying the limitation of right. Now, the first part of section 36 tells you that it needs to be a law of general application. Now, this is based on the principle of rule of law, which we have already done. Now, if we look at the rule of law, it has 2 components. The first component is that the power of the government derives from law. So the first component is the limitation must be authorized by law. So the power of the government, remember it's usually the government that limits a constitutional right. Their power gets derived from law. So they have to have lawful authority for all of their actions. Otherwise, it will not be a lawful government, but it will be a tyranny. So only if we have a government that is being authorized by law to do the actions that they're doing, we are having a democratic, lawful government. Now, the practical effect of this can be seen in the case of August versus Electoral Commission. In this case, the Constitutional Court had to consider the validity of the Independent Electoral Commission's failure to take steps to allow prisoners to register and vote in the 1999 general election. So what happened with the 1999 general election is everybody registered before they voted, as in any election, and only if you're registered are you allowed to vote. Now, the Electoral Commission, which is supposed to be an independent body, as we know, a Section 9 institution, in 1999 they failed to give prisoners the opportunity to register, and they could, of course, then not vote. The court then had to decide whether these steps that they took were valid or not, because the Commission's inaction had the effect of denying prisoners their basic right to vote. And as I've explained to you guys, this right is something that was fought for many years. So in a constitutional country, and that was only our second election ever, for people to be excluded due to administrative mistake was a big problem. So firstly, they were limiting this right, the right to vote. So stage 1, the right was limited. And now the question was it justifiable? But the Electoral Commission, the court then found that their action was never authorized by law. So there's no possibility of justifying the infringement in terms of Section 36 because their action was never authorized. So that is just one example, as August versus Electoral Commission. Now the question is, what forms of law qualify as a law of general application? Now, the Constitutional Court has not dealt with this question directly, but it has given wide interpretation to the meaning of law elsewhere in the Bill of Rights. On the strength of this interpretation, it seems that all forms of legislation, common law and customary law, would be considered a law of general application, but policy and practice would be excluded. So that is the first part of the rule of law. The limitation must be authorized by law. Law. The next part, it must have general application. Now, the general application part is a bit more difficult. Okay, so the law must be general. At the level of form, this means that the law must be sufficiently clear, accessible, and precise, and that those who are affected by it can ascertain the extent of their rights and obligations. Because when people know a law, they know how to act according to that law. Also, it must be applied equally to all. It must not be arbitrary in its application. It must not be impersonally. And then it must be specific people should never be singled out for harsh or favorable treatment. These criteria tells you that a law is general in its applications. Now, if you check on page 156 and 157 on your textbook, you'll see a long quote from Judge Ackerman that he gave in the Makwanyane case, which he explained the idea of general application and why there's no place in our democratic society for laws that single people out anymore. However, so if you perhaps get a question in a test in which I ask you to critically analyze or discuss the law of general application by referring to relevant case law, it would be a good idea to explain general application the way I just explained it, both facets of the rule of law, and then also to give a complete explanation of the case of President of South Africa versus Hugo, and also to make mention of the case of De Lille versus the Speaker of the National Assembly. Now, let's first look at the President of South Africa case. Now, this happened around 1992. Now, what happened was President Mandela issued a presidential act where he authorized mothers who had children under the age of 12 to be released from prison. Now, this act was given in terms of section 82(1)(k) of the interim constitution, which permits the president to pardon or reprieve offenders. So President Mandela took this power given to him by the interim constitution, and being the man that he was, he decided that it would be in the general interest of both women and children if he released women who have children under the age of 12. The problem was that the men, then of course, said this was unfair discrimination towards them because they also had children under the age of 12. Why could they not be released? Now, the merits of the case we will be discussing in a later lesson, but for purposes of the law of general application, you need to know that the majority of the court held that the Presidential Act did not violate the right to equality and non-discrimination, and therefore did not consider the issue of limitation. In order to answer the question, the court looked at the European Court of Human Rights and the Canadian Supreme Court to the phrase prescribed by law. Now, in the ECR, they held that at least two requirements flow from the expression prescribed by law. First, the law must be adequately accessible. The citizen must be able to have an indication that it is adequate in the circumstances of the legal rules applicable to a given case. And secondly, a norm cannot be regarded as a law unless it is formulated with sufficient precision to enable citizens to regulate their conduct. So citizens must be able, if need be, with appropriate legal advice, to foresee to a degree that it is reasonable in the circumstances, the consequences of a given action. So what the European Court of Human Rights was saying is, in order for a law to be seen as a law of general application, or the term prescribed by law, it should be a law that is written in a way that people understand it and that it is accessible to them. So people should know about this law and they should be able to understand it. Then it is a law of general application. They also looked at the Canadian Supreme Court, and there the Supreme Court had consistently held that rules that derive from statute, delegated legislation, and the common law are prescribed by law. More controversial, however, is the question whether norms that emanate from directives or guidelines issued by government departments or agencies, but which are not officially published, delegated legislation, can be said to be prescribed by law. Now, the reason why they were asking these questions is the fact that Mandela decided to release these women was a presidential act. So the question was, is a presidential act a law of general application? The court used two different courts' definition of prescribed by law, both the ECHR and the Canadian Supreme Court, to determine whether it is actually a law of general application. Now, the judge on the matter, Mokgoro, decided to answer this question by using the rule of law. Now, he said the idea underlying this prescribed by law and law of general application is the rule of law. Because rules affecting fundamental rights should always be accessible, precise, and of general application. Remember, we've seen that in the Constitution, where they say that a law should always be generally applied, accessible, and precise. Now, this judge was saying that this is part of the rule of law, and people should always be able to know of the law, and they should be able to conform their conduct to the law. Because if you don't know what the laws are, how would you know that you're acting lawfully or not? So this South African judge was saying, I'm taking into consideration what the ECHR and the Canadian Supreme Court are saying, but I'm answering this question of whether this presidential act was a law of general application by applying rule of law. Now, laws, according to Mokgoro, he said the presidential act complied with these requirements. So the Presidential Act was accessible, it was precise, and it was of general application. Now, as for the argument that the Presidential Act was not law because it was not a conventional delegated legislation, the judge held that the Presidential Act was sufficiently similar to delegated legislation to be considered law. The only difference between the Presidential Act and standard delegated legislation was the absence of an enabling statute. Now, the judge, to summarize, and this you can see on page 159, I will read to you what his approach was to the law of general application requirement. Number 1, law, for purposes of the requirement, includes rules of legislation, delegated legislation, and common law, and exercises of executive rulemaking authorized by the Constitution. As for executive rulemaking, it is not necessary that rules are formally published in the Gazette. The range of rules qualifying as law should not be too narrow. Okay, so in his first requirement, he basically defined what laws are, what kind of documents fall under laws. And then number 2, to qualify as a law of general application. So first he answered the question of what is a law. Now he's moving on to what is general application. He says, to qualify as a law of general application, a rule from one of these sources must be accessible, precise, and of general application. People should be able to know of the law and should be able to conform their conduct to the law. Laws should apply generally and should not target specific individuals. So basically what Judge Mokgoro was saying that yes, a presidential act is a law. The reason being is, number 1, he defines what falls under laws. And number 2, he says that a law of general application must be accessible, precise, and people should be able to conform their conduct to the law. So, this interpretation of him does not make the law of general application a particularly exact one. Almost any reasonably intelligent rule will qualify then as a law of general application. There is not even a requirement that the rule must be promulgated or published. The only substantive qualification is that the rule must be general. Now that was what one of the judges on the case of President versus South Africa versus Hugo. So these questions had to be answered before they even had any chance to determine whether there was unfair discrimination. They first had to decide if this was a law of general application. And this is what Judge Mokgoro used to answer his question. There was another judge, Kriegler. He determined that the Presidential Act was not law. Now, there's reasons for stating that it's not law. You can find on page 159 and page 160. Interesting thing about this case was, even though these two judges disagreed about whether the Presidential Act was a law of general application, they both agreed on the requirements for what general application is. But for Judge Kriegler, the act was simply an executive act of the government. It was an order made by the president and directed to government officials who would carry it out. The order did not have the character of legislation, and moreover, it's quite specific in its application and it's not general. This means, according to Judge Kriegler, that the Presidential Act could not serve as a legitimate restriction of the right to equality. However, good the reasons may be for the Presidential Act, it is not a law of general application and can therefore not limit a fundamental right. So if we go back, the whole issue of this case was, is this unfair discrimination? The men felt that they were being unfairly discriminated against by this Presidential Act because women were being released and they were not being released. The question in front of the court was whether, before they could answer the unfair discrimination question, is whether this act, this Presidential Act, is it a law of general application? Because if it's not a law according to general application, they don't have to do the two-stage test. They only do the two-stage test, which we previously discussed, when it's a law of general application infringing on a constitutional right. So if I ask you this in a test, I need you to discuss law of general application, and then I need you to discuss this case. And you will find the discussion of the case very fully in your textbooks on page 157, 158, and 159. Then on the next page, on page 161, you will also find a very short explanation of Delille versus Speaker of the National Assembly. If you want full marks for this kind of question, you will have to refer to Delille and you'll have to give me about 2 facts. Okay, so if you look at the definition given on 36.1, we've already done the first part, law of general application. So the rights in the Bill of Rights may be limited only in terms of a law of general application to the extent that the limitation is, this is the next thing that we will discuss, reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom. So what it's telling you is that a law that restricts a fundamental right must do so for reasons that are acceptable in an open and democratic society based on human dignity, equality, and freedom. It must not invade rights any further than it needs to be in order to achieve its purpose. And this purpose must be a constitutionally acceptable purpose. And then there must be sufficient proportionality between the. So the first thing we need to discuss regarding this is proportionality. Now, as you know, proportionality is all about weighing 2 different options. The first thing we are weighing is the purpose, the effects, and the importance of the infringement. And on the other side, you need to look at the nature and the effect of the infringement caused by the legislation on the other. So let's say the limitation is the limitation of freedom of movement of criminals. So the purpose will be to stop them, to get them out of society. The effect would be to get them out, get them behind bars, and the importance would be to society. So we have to take that, all of that on the one hand, and then we have to weigh it, against the nature and the effects of the infringement caused by the legislation on the other. So the person that is being limited, let's say the criminal, the nature and effects of this infringement on him weighed against all of this. And only if this weighs stronger will we be able to limit the right. Now, in order to understand proportionality, we must look at State versus Makwanyane. Now, you will see that State versus Makwanyane will be using it a lot with regards to the limitation of rights. The reason being is the first grounds for limitation of rights were actually found in State versus Makwanyane. Remember, this is the case where they abolished the death penalty. Now, this is an actual quote from State versus Makwanyane, in which they say, "The limitation of constitutional rights for a purpose that is reasonable and necessary in a democratic society involves the weighing up of competing values and ultimately an assessment based on proportionality. This is implicit in the provisions of Section 33(1). The fact that different rights have different implications for democracy, and in the case of our Constitution for an open and democratic society based on freedom and equality, means that there is no absolute standard which can be laid down for determining reasonableness and necessity. Principles can be established, but the application of those principles to particular circumstances can only be done on a case-by-case basis. This is inherent in the requirement of proportionality, which calls for the balancing of different interests. In the balancing process, the relevant considerations will include the nature of the right, its importance to an open and democratic society based on freedom and equality, the purpose for which the right is limited, the importance of that purpose to such society, the extent of the limitations, its efficacy, and in particularly where the limitation has to be necessary, whether the desired ends could reasonably be achieved through other means less damaging to the right in question. In the process, regard must be had to the provisions of Section 33(1) and the underlying values of the Constitution, bearing in mind that, as Canadian judge has said, the role of the court is not to second-guess the wisdom of policy choices made by legislatures. Now remember, Section 33(1) is the equivalent of Section 36 in the interim Constitution. Now the important thing here is to see here is Section 36 on the limitation of rights. We can easily see the link. The first factor, the nature of the right. There we go. The second one, the importance and purpose of the limitation. The nature and extent of the limitation. The relation between the limitation and its purpose. And the last one, a less restrictive means to achieve the purpose. So the judgment given in State versus Makwanyane was used to write Section 36 of our Constitution. Okay, so the first requirement is the nature of the right. Here you need to understand that some rights in the South African Constitution weigh more heavily than others. These rights will be more difficult to infringe than others. So for example, freedom, equality, dignity, they are rights that weigh heavier. So then the court must assess the importance of infringing such a right in the constitutional scheme of things. So they're not just going to look at the individual case, they're going to look at the big picture. Infringing on dignity, for example, it's almost impossible to think of a situation where that would be justifiable. So a right that is of particular importance to the Constitution ambitions to create an open and democratic society based on human dignity, freedom, and equality will carry a great deal of weight. Okay, now, very important, if you get a question about the limitation of rights, and I ask you to discuss the requirements for the limitation of rights or the factors identified as making up the proportionality requirement of the limitation of rights, and I say discuss it with reference to State versus Makwanyane, this is what you will be doing. Check your textbook and you will understand better what I'm saying now. What you're going to do is you will discuss each of the requirements of Section 36. You will start with naming the requirement. So, for example, Section 36.1a, the nature of the right. Then you need to discuss that requirement. So you need to explain the requirement for me for 2 to 3 points. And then in each and every example, you will link it to State versus Makwanyane. Now there are 5 different requirements. If I ask each of them for 3 marks, it's a 15-point mark. I can easily ask this for 20 marks. So for test and exam purposes, I would say make sure you can answer limitation of rights by referring to State versus Makwanyane. You can do it exactly the way they do it in your textbook. So, continuing. Remember, we are now discussing the nature of the right. I've told you that some rights weigh heavier in the constitutional dispensation. Now, in State versus Makwanyane, they had to answer that whether the death penalty should be abolished or not. So the infringement would be taking someone's life. So which rights are infringed by the death penalty? So if someone's life is taken, which rights don't they have any longer? The first one, obviously, the right to life. When someone gets the death penalty, they lose their right to life. The second one, the right to dignity, because you cannot have a dignified death. If you're being hanged or poison is being shot up your veins, you cannot possibly say that someone has their right to life or their right to dignity. Then the last one, no one shall be subjected to torture or to cruel, inhuman or degrading treatment or punishment. Taking someone's life, even if it is for the death penalty, is considered to be an inhuman punishment because the end of it is to take someone's life. So the first question in the test, the proportionality test of the limitation of rights, is the nature of the rights. So the nature of the rights in State versus Makwanyane was that the rights to life and dignity are the most important of all human rights and the source of all personal rights in the Bill of Rights. Because they found this, it meant that the whole case got a heavier and a more important view because the right to. Okay, so the next one is Section 36.1b, the importance of the purpose of the limitation. So we've done, the first step is to look at the nature of the right. The second one is the importance of the limitation. Now the thing is that reasonableness requires the limitation of the right to serve some kind of purpose. Justifiability requires that this purpose be one that is worthwhile and important in the constitutional democracy. A limitation of rights that serves a purpose that does not contribute to an open and democratic society based on human dignity, equality, and freedom can therefore not be seen as justifiable. And because of this, the personal morality of a sector of society will not qualify as justification for the limitation of rights. So, just because some people believe in the death penalty or believe in abortion or do not believe in abortion, that is not enough to qualify as a justification for the limitation of rights. So all reasonable citizens should agree that it's compellingly important. Now on page 167, you'll see 7 requirements. You do not need to know these requirements in order to answer the question. Oh, there's 10 requirements. You'll see that there are more requirements on the next page. If you have to discuss this, you can just give the facts as I've stated them here, and then of course discuss it with reference to State versus Makwanyane. Okay, now in State versus Makwanyane, if we take that example again, is the purpose worthwhile? Remember, they were going to limit the right to life, dignity, and the right to not be subjected to torture, to cruel and inhumane punishment. They were going to limit these rights by taking the person's life. So what is the purpose? Firstly, it should be as a deterrent to violent crime, and secondly, to prevent the reoccurrence of violent crimes. And the third one is fitting retribution. So the court stated that there are 3 reasons why they would want to keep the death penalty. The purpose would be to deter people from violent crime, to prevent them, and as a fitting retribution. So the first step was for the court to look at the nature of the rights, which we've looked at. Then the second step is for them to determine what the importance of the purpose of the limitation is. Then the third one is to check the nature and the extent of the limitation. Now in this section, it requires the court to assess the way in which the limitation affects the rights concerned. Is the limitation a serious or relatively minor infringement of the right? The assessment is a necessary part of the proportionality inquiry because proportionality means that the infringement of rights should never be more extensive than what is warranted by the purpose that the limitation seeks to achieve. A law that limits rights should not use a sledgehammer to crack a nut. Now, to determine whether the limitation does more damage to the rights than is reasonable for achieving its purpose, it requires an assessment of how extensive this infringement is. Now, for example, the right to life obviously is very permanent. You will never get your right to life back, which means the nature and the extent of this limitation was an extremely serious one. So, if we look at Makonyani, is the harm disproportionate to the benefits? So the first one, deterrent to violent crime. To prevent the reoccurrence of violent crime and as a fitting retribution. So the question is the harm disproportionate to the benefits? And the court found that in 2 of the 3, it is not disproportionate. Because if you take a person's life, they will be deterred from violent crime forever because they will not be alive anymore, and it will prevent the occurrence of violent crime because the person will not be alive anymore. But fitting retribution in a constitutional state, we should not strive to get retribution. So the court found that it is disproportionate to number 3. Okay, now the next qualification. To serve as a legitimate limitation of a right, a law that infringes the right must be reasonable and justifiable. This means, put at its simplest, that there must be a good reason for the infringement. It also means that there must be proportionality between the harm done by the infringement and the beneficial purpose that the law is meant to achieve. Logically, this requires that there be a causal connection between the law and its purpose. The law must tend to serve the purpose and that it is designed to serve. If the law does not serve the purpose it is designed to serve at all, it cannot be seen as a reasonable limitation of the right. If the law only marginally contributes to achieving its purpose, it cannot be adequate justification for the infringement of a fundamental right. Now, if we look at State v. Makonyani again, does the death penalty serve the purpose number 1 and 2? The first one, deterrent to a violent crime, and the second one, prevent the reoccurrence of violent crime. Yes, absolutely it will prevent the reoccurrence of violent crime because, as I've said, the person is not alive anymore. But number 2, is it deterrent to violent crime? Now, the court found with a number 2 that there's undoubtedly a rational connection between the means and the ends, because it effectively ensures that criminals will never again commit the violent crimes, for they will be then executed. But regarding number 1, the purpose of deterrence, the same cannot be said. Determining whether an infringement of rights is justifiable is a factual inquiry. Therefore, if the state wished to show that the death penalty deters violent crime, it would have to adduce evidence in support of this contention. According to the Constitutional Court, there was no satisfactory evidence establishing a connection between the death penalty and its reduction in the incidence of violent crime. Because it's very difficult to prove that the reason people don't do violent crime would be because of the death penalty. So if we look at the death penalty question, does the death penalty serve the purposes as the court would have asked? We can say yes, it will prevent the violent crime from happening again from the same person. But will it deter others to do violent crimes? Now that is an open question. Okay, now we have section 36(1)(e), which determines that less restrictive means to achieve the purpose should not exist. In a nutshell, it basically says that the purpose that the government is restricting the right for, there should be no other means to achieve that same purpose. It's because the benefits or the purpose that they want must be in proportion to the cost of the limitation, because the limitation will always be restricting someone's right. So the cost of that restriction should always be in proportion to what the benefits are. No other means could be employed to achieve the same ends. That will either not restrict rights at all or not restrict them in the same extent. Now, if a less restricted alternative exists, they must be preferred. But a margin of discretion is given to the state. Okay, now let's look at State versus Makwanyane again. Are there other less restrictive means to achieve purposes 1 and 2? And the thing the court kept saying was, yes, we hear why you want death penalty, but there is less restrictive means. Life imprisonment. If you put someone in prison for life, they cannot commit violent crime to the general public again, and it will deter them of violent crime. Okay guys, that's the end of your lesson on limitation. In this lesson, there's a couple of things you can really focus on. A longer question that can definitely come from this one is a 15 to 20 mark question either here or in the exams, which you will have to discuss the criteria for limiting a right according to section 36 by referring to State versus Makwanyane. What this means is you will have to discuss each of the requirements, give me an explanation of each, and then refer to how the court approached this in State versus Makwanyane. You need to know this in detail because I can ask you all of them for a longer question, or I can ask you one of them for at least 5 marks. So this work, you really, really need to know this work. I would also then say, look at the law of general application as I've explained to you and be able to critically analyze that work with reference to President versus Cjua042. So make sure you know that case, you know what's going on in that case. Not the facts, but the legal principles that came from that case. So this is the end of the first electronic lesson. Your next electronic lesson will be about equality.